Hi, welcome back to the podcast HOA Hell. I'm your host, Michael Kushner, and with me as always is Senior Associate from MBK Chapman, Sam Kill. Sam, good morning.
Morning, Mike. Glad to be with you.
Good to have you. Sam, today we are going to talk about a topic that I wrote about in my fact sheet from yesterday. I will put the description I'll put the link in the description for this episode. And that was something that we are seeing a lot of people ask us, both in person and online. And when I say in person, I'm talking about obviously during consults, is how do you sue your HOA? What are the steps that I'm going to have to undergo? Or when it's in writing or saying, can somebody describe the steps it takes to sue your HOA? So I wrote a fact sheet on that and I decided let's do a podcast episode as well. Okay. So today we're going to provide homeowners with a step-by-step guide on what it takes to sue the HOA. We're not going to be handling neighbor-to-neighbor disputes and lawsuits against neighbors. We're just going to assume today it's the homeowner versus the HOA. Okay, that's going to be our limit today. So obviously, homeowners that are dealing with selective enforcement, architectural guideline disputes, arbitrary decisions, excessive or unfair fines, all of the stuff that make up the gamut of disputes with their HOAs, those are all subject for lawsuits. Okay?
Exactly.
And one thing that we can say with a certainty is that lawsuits are not won on or even brought properly on mere frustration or they're not driven by frustration. They're driven by legal claims. Legal claims have specific elements, and those elements have to be alleged and proved for there to be a successful lawsuit. And so that's what we're going to talk about today, okay, in general. We aren't going to focus on the elements of any particular type of cause of action, but I just wrote a fact sheet earlier this week on the actual elements for a case for breaching the CC&Rs against an HOA, and we did that because we're seeing that a lot too.
Yes.
But we're not going to do that today, okay? We're going to speak more generally. So today is not about assuaging people's anger or dealing with the emotions behind it. We're dealing with the legal steps that are required to successfully bring and prove a lawsuit, okay? Because that's what courts look at. Courts don't evaluate the frustrations and emotions unless you're seeking emotional distress damages, right? Which I'm writing about today. In the article I'm going to be publishing today, I'm writing about emotional distress. But viable cases are structured, okay? They follow certain rules and guidelines that are set out by statute and the courts, and that's what we're on today, okay? So I guess we'll call it step one. Let's identify the legal claim, okay? The first step in any lawsuit against an HOA is to figure out what you're suing for. That's what I mean by identifying legal claims. When we use the term legal claims, it's another way of saying a cause of action. If you've ever seen a lawsuit, if you've ever looked at an actual lawsuit and you look at that front page, that caption, there is often more than one legal claim or cause of action, and they're usually numbered on the right side of a table. And it might say something like complaint 4 and have a colon, and then you have a list of numbers. And that's where you see things like breach of contract or breach of CC&Rs, negligence, breach of fiduciary duty, nuisance, trespass, all the dozens of claims that are out there. Those are called causes of action, okay? Now, in HOA parlance, there are the more common causes of action. Yes, once in a while you get a false imprisonment cause of action. If somebody locks you in a room or blocks your way, won't let you buy, technically it could be false imprisonment. You get that once in a while, and those are fun. But Sam, just give me a handful of the most common claims we see in HOA homeowner cases.
Mike, well, you just alluded to many of them. The most common ones are breach of contract or breach of the CC&Rs. It is negligence. It is a nuisance claim. It is a breach of fiduciary duties.
Okay.
And it's a declaratory relief.
Right. What is declaratory relief in one or two sentences?
Well, it's essentially seeking a decree or judgment from the court, finding or assisting with the interpretation of who's entitled to what under the governing documents.
Basically, there could be a dispute as to what this means or what my duties and obligations are as to this issue in a contract. And the court will declare that one of you is right.
Correct.
Here is what your obligations are. You would, and that is I consider it kind of a catch-all when there's a dispute on interpretation or some vague provision, or I'm saying this because that's what I read the documents tell me, and then they're saying, no, it's this. Somebody needs to tell us who's right.
Exactly. Am I entitled to this remedy or not?
Exactly.
Yeah.
Yes. And so those are the most common ones. Now, there are also ones that we use terms for, but they aren't individual causes of action. They're something else. For example, selective enforcement. There's no independent cause of action for selective enforcement that you'd see on that caption page, but it forms the basis or the facts behind different kinds of causes of action. It could be breach of fiduciary duty. It could be negligence. It could be breach of CC&Rs.
Right.
Selective enforcement is a description of conduct. It's not the claim. Okay.
Or you could have a breach of a statutory provision.
And that's where I was going next.
Yeah.
So he gave the ones that we use a lot, but then there are multiple statutes. If they're violating your solar rights, we might sue under those facts under some of the ones he mentioned, but we might also sue under breach of this statute. If they are denying you document rights, we might be suing under breach of 5200. If there's a reserve study failure, that's often a negligence, and it's often breach of fiduciary duty, but it would also be a statutory breach. The same facts, in other words, can underlie multiple causes of action. Now, give me one reason that you can think of why a lawyer would allege two or more causes of action for the same set of facts. Why not just allege the one that works the best?
Well, because it can give you a meaningful strategic advantage also from and we'll get into this, the fee shifting related considerations. Because one may give you, well,
let's not get into it yet, but
a meaningful advantage.
Okay, that's good. There could be a fee shifting issue, which we'll discuss later. Another one is some causes of action, the elements of some cause of action and the remedies available are different. There might be a different standard of proof, or more likely, you are entitled to a certain remedy under one cause of action that isn't available in another. I'll give you an example. Let's say somebody comes in, let's say the HOA goes into your property and onto your actual separate property and wrongfully cuts down one of your trees. I would certainly call that negligence, and it would fit under trespass. But there's also a specific statute on an intentional destruction of trees. And that statute for intentional destruction of trees gives you the right to claim treble damages, which is triple damages.
Punitive, yeah.
So in a negligence claim, you could claim the value of the tree. Those are your damages under negligence. There's no triple damages available in a negligence cause of action. But under the tree statute, there is. So you would allege negligence and you would allege trespass, but you would also allege the tree one because that gives you the chance. Let's say the tree's 10 grand. You now can allege damages for $30,000 under that, while the negligence claim only gives you 10. Now, if you win, you're not going to get the 30 and the 10 added. No, that 10 is built into the 30.
Yeah.
Okay? It's just 3 times your actual damages. But the point is, you have remedies available to you in different causes of action that differ from others. That's the big reason. His is a good one too, though. So it always pays to list multiple and that's why you see so many, to list multiple causes of action, because there are different legal theories, different remedies available for those, and different standards sometimes of proof. Okay, so your HOA is negligent by failing to maintain a common area roof, which is resulting in leakages, right? What's the legal claim? It's a failure to maintain. That would fall under negligence. If it's really gross negligence, it could fall under breach of fiduciary duty, and it's certainly going to be a breach of the CC&Rs, okay? Because assuming the CC&Rs provide that maintenance requirement. And if it doesn't, the default kicks in on the statute anyway, 4775, which puts it back to the HOA anyway. So either way, it's going to be breach of CC&Rs.
That's exactly it.
Okay.
Yeah.
So that's step one. You got to identify the legal claim. In other words, what are you suing for? What cause of action are you going to name? Step two, identify the proper defendants and confirm standing. There's two issues. I'll separate those. What do you mean by proper defendants?
Well, in other words, you have to identify the parties. I mean, who is it that you're making these allegations against? The
HOA.
HOA.
What does that mean?
I mean, the HOA, you name them generally in connection with these types
But what
of
does that mean? I'm naming the HOA. What is it? Who am I suing?
Yeah, you're naming the entity, the nonprofit corporation.
It's very likely a nonprofit corp.
Yeah, it very likely is in California.
Yeah.
And you're naming the entity. And this is a very frequent source of confusion where folks can conflate.
Let me ask you a question.
Yeah.
When you say entity, you're talking about a corporation, right?
Exactly.
A corporation can be sued? I mean, that's what we had asked. Well, wait, there's nobody I'm suing.
Yeah.
No, the law treats a corporation as a person.
Exactly.
Corporations can own property. They can enter into contracts in the name of the corp as if it's a person. They can be sued, and they can be liable for damages.
And for the
without naming any individual people.
For the conduct or misconduct of its directors, officers, et cetera.
Its board, its officers, its managers.
Agents, yeah.
Anybody that's acting on their behalf at their instruction. Yeah, exactly. You sue. So you're identifying, in this case, I started at the beginning by saying we're talking about lawsuits against the HOA. We're not talking about lawsuits against neighbors and stuff. But you identify the proper party. Now, we hear all the time, I want to sue the HOA, of course. I want to sue the directors personally, too. Tell me about that.
Well, the directors are, for the audience, and we have done numerous full-form episodes on this in our podcast.
I'll put a link in the description to at least one of those prior podcasts and to maybe one or two of the articles I've written.
And real quick, as an overview, directors are layperson volunteer members who get on these boards to represent the association. So directors and officers who are part of the board of directors are working on behalf of this entity that we mentioned.
That's right.
So unless we have a scenario where we have a personal, let's say, misconduct as in a tort or tortious interference, or we have some
bad
kind
faith.
of or an assault or some action, bad faith or malice, undertaken by one of these directors,
then they have indemnity.
So what you do is you name the entity because all of these directors fall under that umbrella, including any agents.
That's right. So let me just make this clear. We talked in other episodes about the business judgment rule. Business judgment rule is that presumption that the acts of the board were done in good faith, et cetera. Under Corporations Code 7231, directors have a duty to act in good faith and in the best interest of the corporation. That duty is a fiduciary one. And so if you have a director that has committed an intentional tort like assault, he brought that up, assault or battery, and we've had that. We've had a director like punch somebody. We've seen those things, but then they can be held personally liable. Also, if they act in bad faith, they're grossly negligent, or they act outside the course and scope of their director duties.
That's a big one.
We did one of our early episodes, and you weren't guesting in that. I had a client of ours. Okay, as a guest in that episode, and that was the one on where we had video of a bad HOA director.
Oh yeah, and
in that show, I showed a 5-minute clip in that episode. For those of you who haven't seen that, I urge you to go find it. The pictures it shows like a toxic waste sign. That's how you'll be able to identify the picture, and it's identifying or spotlight on a bad HOA director. I urge you to watch at least the first 15, 20 minutes of that because that video is a hoot. Okay, that is a lot of fun. If you want to see a director commit a legal assault, okay, not quite a battery, but an assault, go act outside the course and scope of their duty and actually be so insane as to, and this was back when COVID was in full swing, to claim that the person filming him was not wearing a mask when the person put the camera on himself, you could see, even though I blurred the faces, you could see he was wearing a mask. But anyway, if you want to see a great video, that's one to watch. In that situation, that director was sued, was held personally liable, and can be. Okay? So, very good. All right? So you want to identify the proper defendant. In our examples today, that's the HOA.
Yeah.
maybe individual directors, depending, okay? Again, bad faith, gross negligence, intentional torts, breach of fiduciary duty, self-dealing. We've had episodes on conflict of interest. They've got, their brother George, they awarded the contract to their brother George without disclosing to anybody that their brother George owns that company.
Yeah.
That's conflict of interest. I'm going after the director. But other than that, we aren't doing that.
Or the board president is a real estate agent interferes with your marketing and sale of your property because they have another listing that's competitive within that same community.
It's interesting you bring that up because I feel like you just told me about a case that we have with that exact set of facts.
100%.
That's exactly one of his cases that he is currently working on, and we literally just had that meeting last week, and that's exactly the facts. And it's anyway. Okay. Now, very good. Let's talk about standing. Standing is this weird legal concept, but it's very simple. Do you have the right to bring this lawsuit? Have you been damaged personally such that you have a right to seek a claim? Now, we're talking about personal lawsuits today only. We're not dealing with derivative lawsuits. I'm not even going to define what that means. For those of you that know, we're not talking about them, okay? So either you have been personally hurt or injured and gives you a right to seek relief, or you have a right under some sort of contract like CC&Rs to bring relief, or a statute gives you that right. We do have in California, not in the context of anything we're talking about today, but there are some HOA disputes that fall into this where the statute gives people rights by virtue of the statute giving you the right, even if you haven't been personally harmed. We're not going to focus on those today, but that's standing. Are you the right person to sue? Let me give you an example. I live in an HOA, I'm a member. I want to sue the HOA for failing to enforce or for violating one of its obligations from the CC&Rs. I'm going to sue for enforcement. Breach of CC&Rs is going to be my first cause of action, okay? I have standing by virtue of the fact that I am a member of the HOA. That gives me standing. Now, in that particular breach of CC&Rs, if I, in the middle of my lawsuit, sell my house, I am no longer a member. If I sell the house and title transfers out of my name into the buyer's name, even if I'm still living there as a renter for 60, 90, 100 days, I'm no longer a member. That lawsuit's going to go away. I lost standing. I'm no longer allowed to stand before the court and say, give me justice because I sold that house. That's what we mean by standing, okay? But in most cases, just for those of you, if you want to remember it, you've been personally hurt by, you've been harmed by conduct and you've experienced that harm, okay? That's really just a good way to remember it, okay? Or typically, if you're a homeowner and you're dealing with your HOA, you have standing. If you're not, you probably don't. Now, there are certain causes of action where even if you do move and you give up your membership, you can still pursue those. We're not going to get into the difference today. That's a complicated separate issue, which we may or may not ever do a show on. So, example, I submit an application to build something in my, add a balcony or whatever. Okay, anything. I want to make an improvement. I properly submit the application. HOA denies. Says, nope, not going to let you do it. Sorry, it doesn't fit into our aesthetic. I look around and I see 15, 20 other homes in my community with the exact same balcony or whatever. Exact same one, no difference. How is it that fits? Those fit into the aesthetic and mine doesn't. Classic case of selective enforcement, right? So I'm going to file a lawsuit. Okay, if I can't get them to change their mind and I'm entitled to this, I might file a lawsuit, okay? The theory behind my causes of action, whatever they are, is going to be selective enforcement. And because I'm a member and because I made the application was denied, that's the harm. I've been hurt personally. I have standing.
Yeah.
Okay. Step 3, gather documents. Now, gathering documents can occur and should occur before you ever file and, of course, during the course of. I'm going to ask you to tell me, what do I mean by before you ever file and how do I go about getting those? Be brief. And do comment on the fact that we've probably done or mentioned a dozen or more episodes. And there's 13 or 14 fact sheets on my website handling different aspects of this one thing. Go. I'm leaving it all in your hands.
Okay. Well, we've emphasized gathering documentation and documenting all communications, all submissions of, let's say, if it's an architectural issue, applications, supplementing those, any type of a back and forth, including whether you have attempted internal dispute resolution or anything to that effect.
How do I get those?
Inspection reports, any of those. Now, the way you get the vehicle, the primary vehicle that you get to those pre-litigation, and remember, this is all part of a structured framework to prepare for the filing of a lawsuit.
Right.
So we're still in pre-litigation.
We're still in. No lawsuit exists yet.
And the primary vehicle in terms of getting to these documents and records, other than your own personal records that you are in your possession, would be under Civil Code Section 5200.
Yes, and that's what we've done.
Numerous
shows on.
Great fact sheets, yep.
We've done several actual shows on it, shorts and longs, but we've mentioned it in, I'd say, 20 to 30 episodes.
Yeah.
Maybe more.
Probably over 50.
And as I said, I did a 10-part series of fact sheets on 5200, all handling narrow aspects of it so that you could get, I did one umbrella, and then I did a bunch of narrows where, okay, what happens if they deny you? Here are your remedies. What happens? What documents are you entitled to? Here are those. And then we did a general. And if you want to look for those, the pictures I used were chessboard or chess pieces for every one of those. So if you see a chessboard or chess pieces, chances are you're in one of the 5200 fact sheets. But that is the pre-litigation mechanism every member is entitled to, requests HOA-related governance documents. And I include in several of those a list of just a whole gamut of documents you're entitled to. Financial records, blah, blah, blah. You're entitled to a lot of stuff, okay? So let's talk about that architectural dispute I used in the last example. You said something interesting just now because it's not listed in 5200. And that was the architectural plans of, and I assume you meant other people because I have my own. So he hinted at the fact that, yeah, one of the things, let's say in my example from the last step, I was denied my balcony, right? I'm going to be seeking architectural plans of some of those other people that I know have those balconies because I've taken video or pictures of them, so I know they exist. And even though that's not listed specifically under 5200, courts have made it clear that it is at least if you're talking about exterior plans.
Exactly.
You very likely, under court-made law, have a right to that document. What you don't have a right to is other people's plans for their interior. To the extent the HOA is even, more in a condo situation, if you're dealing with something that's structural, I guess you would have to do an application, even if it's on the interior. That would be completely private. You're not going to ever get, pre-litigation. You're never going to get somebody else's plans for the interior of their house. But exterior, you're entitled to them, okay? So that's what you were referring to, and that would be under 4765. So what are some of the documents, broad categories that we routinely either will do for our clients or we ask our clients to get, whichever is the case, under 5200?
Yeah. Well, if they don't have a full set of their governing documents, first off, a full set of their governing documents.
Yep.
2, minutes and agendas for the association. If those are not readily available through a portal or otherwise available to
and most of the time they aren't, but they should be.
Correct.
Yeah.
Reserve studies, financials.
Yes.
I mean, we're talking about canceled checks.
No specifics, just because we're going to plow through.
Tax returns, both state and federal for the association. That
depending on the nature of the claim. If there's no financial issues, we don't need any of that.
Vendor contracts is another one.
Like contractors,
exactly.
landscapers, painters, whatever.
Right.
Oh, management
contracts. That's a huge one. That comes up quite
especially
a bit.
When the manager is the source of the wrongs. You want that manager contract.
There's some 20 or so categories that are articulated under 5200. And the fact sheets do a fantastic job of fleshing those out and referring to the subsections that are pertinent to each one of those.
Actual statutes that give you the right to the specific documents. Because remember, if you've read any of my stuff or watched our prior podcasts on this issue, you know that when you prove that an HOA has wrongfully withheld documents to which you're entitled, not only are you entitled to your attorney's fees, okay, but up to $500 for each category of documents denied to you. Yeah. When we talk about categories, check registers is one category. Bank statements is a different category. It's why we separate them all. You can have 20, 25 categories of documents. That's 500 times. Now, if the court can award up to 500 for each of those, but that's in the discretion of the court.
Yes.
Okay. So yeah, he listed, those are the common documents that we want to see. Obviously, specifics will determine or be determined by the nature of the wrong that I'm suing for. If I'm suing for financial mismanagement or some financial harm or embezzlement or something like that, then financial is going to be more important to me than a maintenance contract with the landscaper. But if I'm talking about selective enforcement, those plans are going to be pretty important.
Exactly.
As will minutes and agendas for executive session meetings as well, which we are entitled to.
And perhaps reserve studies and things of that nature, because you can extrapolate quite a bit from those.
Exactly.
As well. Yeah.
So the evidence has to prove. And the reason we need these documents, or they're helpful, is because you can't just say you are selectively enforcing because other people have their balcony and I don't. And it's the same balcony, so give me my money. It's not how it works. You've got to prove it. You've got to have photographs that show what other addresses have the balconies. Are those balconies actually the same or similar enough to be the same?
Exactly.
You have to prove. And the way to prove is with documentation. Okay, documentation can mean photographs, it can mean letters, it can mean emails, it can mean specs and plans, it can mean invoice, it can mean anything that's documentary. All right, it can even mean video. It's not film anymore, but it could be a video file. That's a document. Okay, and you have to take that evidence and tie it to a legal obligation that the board has, either through CC&Rs or the law or both. So I'm alleging that you did this. You're not allowed to do that because of this provision of the law or the governing documents, or you were supposed to do this and you didn't do it, and here's the proof.
Yeah.
That's why we need that. It ties into it helps you prove the necessary elements of whatever cause of action you're trying to prove. So, drainage damage claims, CC&R maintenance obligations, photos of conditions, repair estimates, notices to the HOA, like, hey, I put you on notice over the last 3 months on 6 occasions that we have a severe leak and you've done nothing. And now my $50,000 boom boom thing has been damaged. And now you have to pay me for that because that was an antique. That's going to be important because you put the HOA on notice. All that stuff. All right. Anything else on 5200? I think we covered that to death.
That was pretty good.
And like I said, you could watch hours of our stuff and we've talked about it ad nauseum. Step 4, consider IDR. What do I mean by just consider IDR?
It's important to discern whether your matter, and given the nature of your issues and dispute, and also the nature of your relationship with this board or board members, lends itself productive to having, let's say, an internal effort, a good faith, informal meeting with one or more of your board members to explore the possibility of resolving this amicably, or at least avoiding a legal escalation.
So what you mean, though, when you're talking about whether or not it's worth pursuing, is you're looking at, do I think, is this going to be a complete waste of time as a foregone conclusion, or do I think
there's value in it?
There's some value in it, either because I know that they can be reasonable, or I can be reasonable and they can be reasonable, we can sit down, or is there such a antipathy, or such maybe abrasiveness, or such a difficult relationship that it's just not going to be up front, it's never going to work. The beautiful thing about IDR, internal dispute resolution, as opposed to ADR, alternative dispute resolution, is that IDR, if the homeowner makes the request, is mandatory on the part of the HOA. They must agree to assign one or more directors to sit down. Now, that sit down can be virtual by Zoom, or it could be by phone, or it could be in person, but at a mutual agreeable time and place to try to work out the dispute. But if the HOA asks or demands it, it's completely 100% up to the discretion of the homeowner, regardless of whether or not it's reasonable or not reasonable. The homeowner can say no, even if it probably would work. So it's a one-way statute, and homeowner has control. But it's not always recommended. Who decides whether it's recommended? You do. We never interfere with that. If somebody calls our firm and says, should I do IDR? Our answer is, you tell me. Do you think it'll be worth it?
We help him with a brief analysis, given the facts and nature of the dispute.
But that's it.
Yeah.
Okay. Now, that's IDR. Very simple. Let's move on. Next step, 5. The ADR one. Determine whether pre-litigation ADR is required or not. Remember, IDR never, ever, 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 ever required, even if, and I've seen this before, Even if your HOA's governing documents or rules or their disclosures at the end of every year require IDR, it's not. You could say, not required, okay? ADR, alternative dispute resolution, is sometimes required, okay? Now, when we are talking about regular litigation and the big world of civil litigation, ADR means a couple different things. And broadly speaking, there are two kinds of ADR: mediation and arbitration. We are not talking about arbitration, but for those that don't know, arbitration is basically the same as going to court and having a trial, except that it's done privately through a company like JAMS, and it's only required if you've entered into a contract where you've agreed to do that. Otherwise, you have a right to go for a jury or judge and have the court hear you. But in arbitration, there's a weighing of evidence. There's evidence that's presented under oath. There's testimony of witnesses. And then there's a binding decision that's often made by the arbitrator, and then that can be entered into the court as a judgment. Mediation, not that. Mediation is a fancy legal word for informal settlement talks before a neutral third party. Instead of an IDR where it's you and the HOA sitting down, it's an ADR, i.e. a mediation in the HOA context, is you and the HOA sitting down and also a third party neutral, often a retired judge. And that judge's role is to facilitate, if possible, a settlement. A compromise. Both sides takes less than they want or less than they think they're entitled to. And can we work this out so that it goes no further? Now, unlike IDR, in certain cases, ADR is required under the Davis-Sterling Act. But it is actually not required in more cases than it is required. Contrary to what some other homeowner-side law firms have opined in their writings, ADR, i.e. mediation, is not always required, not even close. So let's talk about when it is. We're talking about Civil Code 5930, and 5930 basically says, okay, here's when ADR is required, okay? In any enforcement action where the party is seeking writ relief, declaratory relief, or injunctive relief, or a combination of those three, or if the homeowner is seeking one or more of those three in conjunction with money damages of less than $12,500. Why is that a magic number? Because that's the maximum threshold for what?
Small claims court.
Small claims court. So by definition or by implication, small claims court, if you can file your lawsuit, or if you do file your lawsuit in small claims, then ADR is never required. Because small claims cases are exempt from the ADR requirement. So, in most cases where people are seeking money damages, they're going to be more than $12,500. So, it takes it right out of the mandatory ADR requirement right there and then. Even if we are seeking injunctive, declaratory, and or writ relief, if we're also seeking $12,600 or even better, $12,501 or more, we're not required to do ADR. Okay, we're not required, but we recommend 98% of our clients try ADR first. And I'm going to tell you why in a minute. But before we do that, I want to talk about consequences. Let's say yours is one of the cases where ADR is required. So it's called pre-litigation ADR. And again, in the context of HOA disputes under the Davis-Sterling Act, ADR equals mediation when we're talking about pre-litigation disputes, okay? So when you are required to mediate with your HOA before you run off to the courthouse, what are the consequences for failing to do it? I want you to answer this question in the context of two scenarios. One, the HOA calls you out on it and what they could file, or if the HOA doesn't call you out on it at all, and it goes all the way to trial, can there be a consequence? Go.
Well, under the scenario you outlined, Mike, in the first hypothetical, if the HOA calls you out post-filing of your legal action or your lawsuit where ADR mediation pre-litigation was required, the HOA may file what's called a demur in response to your complaint, in which case the court will look into that and it'll likely be granted based on those
sustained. Yep.
Sustained.
And what happens if that happens?
And if that happens, your case will likely and foreseeably be tossed out of court. It'll be dismissed.
Now, it's not going to be tossed out with what we call prejudice, which means you can never file it again.
Yeah.
What they're going to say is, well, case dismissed. Go and mediate.
Exactly.
Then come back if it doesn't settle. But your case is gone. You just wasted all that time. And I don't think you get the benefit of the refer back statute of limitations. So if you filed this lawsuit at the end of a statute of limitations, you're going to be screwed.
Yeah. The second facet, which you asked about, is if they do not file this demur and if it's not dismissed.
So let's say the HOA just files an answer and it goes all the way to trial.
Goes all the way to trial. At that point, this means...
And you win.
And you win. This will foreseeably impact your ability to recover your attorney's fees.
Well, no. I think it'll determine how much I get in my attorney's fees.
Correct.
Okay?
Yeah.
So 5950 basically says if a party unreasonably failed to engage in pre-litigation mediation when it was required, the judge can take that failure into account in determining how much to award. Because remember, when you prevail in a enforcement action, you are entitled to your attorney's fees. But how much you're going to get could be up to the judge if you failed to engage in mandatory mediation.
Right.
The judge could cut your fee significantly for that failure. Now, it's up to the judge. If the judge says, well, the reason you didn't do it was reasonable, and the HOA didn't demur, so you're good to go, then you're gold. But it's a potential consequence. Again, there have been some lawyers that have erroneously written in published articles that you waive your right to attorney's fees. That is not true. That is not true. The judge can cut them. And that's why do that?
Yeah.
I mean, that just makes no sense. You're just shooting yourself in the foot. No reason for it. That reduction is controlled by 5960 of the Civil Code. I might have given a different code section, but it's 5960. Okay? Now, I think we've covered ADR, yeah? Do you agree?
Absolutely.
Okay.
Yeah.
So when it's mandatory, you have to do it. And remember, if it's mandatory and you're running up against a statute of limitations, there is a tolling window. And I have an article, a fact sheet on that issue that you can find, so I won't go into it now. So you could conceivably be okay anyway, but you got to do it, okay? If it's not required, then it's often a good idea anyway. Why is it often a good idea? Even when it's not required.
Well, there are many reasons for it, but here are a few reasons. One, it's a cost-effective measure to really give it a good shot.
Why?
Why? Because litigation can be extremely expensive.
It is extremely expensive.
And if there's an opportunity to resolve the dispute pre-litigation, also highlighting your good faith efforts in doing so, especially when...
Let me interrupt you then.
Yeah.
Hold on. I love that you said that. I want to comment on that one thing and then go list the others, okay? You say just now two things. You said it's less expensive, and you said it shows good faith. Okay, eventually, because you're looking eventually down the road at a judge, at a potential lawsuit that doesn't settle. That part's easy. The money thing. We can take people through pre-litigation, the entire process of pre-litigation, including mediation, for usually, on average, under 15 grand. You kind of have, where your money trail is going to end. Litigation, it's an open checkbook. If it goes all the way to trial, it could be anywhere from $150,000 to $500,000 or more, depending on how many experts. Cases can vary. Some cases you can litigate for 120 grand, and other cases it might take $500,000 or more.
Exactly.
Okay.
Yeah.
So 15 grand versus that, right?
Yeah.
Much better deal. So if there's a reasonable possibility of settling it at pre-litigation, it is infinitely better for you. Infinitely better.
The other big reason is time.
And it's quicker.
It's much faster.
A few months versus a couple of years.
Yeah.
Okay. What else? And besides good faith as well, what else?
Well,
tell me about remedies.
Well, remedies would be, if let's say if the whole effort is to no avail, or if ultimately a no compromise is reached and you file a lawsuit, you can actually claw back attorney's fees going back all the way to pre-lawsuit all the way to the ADR mediation.
So even though you filed your lawsuit 4 months after you did your ADR demand, if you went through the ADR process and then eventually doesn't settle, you go to lawsuit, you win, you get your fees not only back to the day you filed or right before you filed, but all the way back to the pre-litigation.
Right.
Yes, but how about this? In pre-litigation, there are remedies that we can negotiate because everything's negotiable.
That's big, yeah.
Everything's negotiated. When you are in pre-litigation and mediation, you can fashion very creative remedies that'll make you happy. And so you're entitled to you can settle for things, you can settle for concessions that you would never be entitled to if you end up having to sue. You couldn't get that. One perfect example of that is this. We've actually negotiated in settlements having directors step down from the board and not run for 10 years, let's say. That is never, ever going to be a remedy that you can get in court unless the director is illegally sitting on a board. Like the director's not a member, he's a renter, or she's a renter. You have to be a member to be on the board by statute, and therefore, the court will come in and say, get off the board. But other than that, courts do not step into the democratic process to say, all right, because you've been such a jerk, get off the board. They won't ever do that, but we could negotiate that in a contract. That's just one prime example. So you are entitled to creatively fashion remedies that you wouldn't be able to force on the other side in litigation. Good. Step 6, you got to choose the right court. Here's what I mean. I don't mean, do I sue in LA or Orange County? No, you sue in the county where your HOA is located. I don't mean that. I mean small claims or superior court. Now, we talked a few minutes ago about the limits. Money limits of small claims is what?
$12,500.
$12,500 for individual suing. Right. Okay. And that's what we're talking about today. So it's $12,500. Okay. So if your damages are $50,000 or $100,000, they've not let you. There's no rules in the governing documents barring renters, long-term renters over 30 days, but they denied you the right to rent. And you've lost out rent for, months. It took you 2 years to get there. Now you've got, 36 months of lost rent at $3,000 a month. That's going to be over $100,000, right? If you're over $12,500, you can't sue in small claims court. You're going to superior court. That's easy. What else? And then what kinds of cases don't lend themselves to small claims? Even if a statute says, if you want, you can go to small claims for this, like election.
Sure.
Right?
In short, it's more complex cases that require the court's oversight or continued involvement in terms of remedies. For instance,
why? A judge is a judge, isn't he?
When you're dealing, you're dealing with actually commissioners in small claims who, although they have contempt powers and they have certain powers that other civil unlimited court judges have as well, their role is far limited. When it comes to injunctive relief, declaratory relief, court oversight in terms of actions to take, actions not to take by the board, or to cease and desist from refraining from certain conduct, they do not remain involved after they issue a judgment.
Now, why is that? Parties. Why is that? Is it, in other words, I think what I'm hearing you say is that, let's do this. In regular superior court, if a judge grants an order saying, I order you to do or not do something, and 2 months later, that party is still doing or not doing whatever they were ordered, parties can go into court, file a motion for contempt. The judge can look at all the evidence and say, you're in contempt, and lots of really severe remedies can result. Small claims court, the judges technically have powers like that, but there's very little mechanism.
There's no pleadings. There's no law in motion.
There's no law in motion.
Effectively, it's very streamlined.
They don't monitor cases.
Yeah, you're in and out, essentially. In some instances, you have the appellate element to it. You can appeal judgments, but that's it, really. You don't have discovery, or at least not formal discovery, depositions, things of that nature.
You don't get any of that. There's no written discovery.
It's really limited.
In other words, the small claims courts are not set up for a judge to have continuing oversight of a case. The small claims is set up for lay people to come and argue their case. The judge takes the matter under consideration, issues a ruling, and it's over. Signs a judgment, and you're done. So complex cases involving more than $12,500 in money damages, or cases that require ongoing judicial participation, either because there's orders that need to be followed later, those usually don't lend themselves very neatly to small claims. Notwithstanding the fact that there's actually a statute, the election dispute statutes specifically authorize people to go to small claims, and yet even though that's authorized, it still might not be a good idea. You're not required to do it. It just authorizes you. We don't recommend doing that, and I have articles on that very issue that you'll find on the website. So it's such a issue that there is something called the judge's bench guide. Right? It's a guide. It's like a book that judges get when they become judges. And it kind of goes through like little tips and tricks and things that they kind of how they should do certain things. And the bench guide for small claims judges actually talks about the fact that you should try to avoid giving injunctive relief or any orders that require ongoing management from you because you're not set up for it. And it actually recommends against it. That's what we're talking about. It's not something we're making up. It's a real thing. So small claims is for more simple, simple things where you're seeking
relief.
You're seeking a money relief of a small amount, or you're seeking, it involves an order from the court saying, hey, turn over those documents.
Yeah.
Okay. But it's a one-off order that you could go back and say, hey, they didn't do it. But even then, it's kind of weird, right? So everything else belongs in the Superior Court. Everything else. Now, in small claims court, you don't get to bring a lawyer. That's the point. Small claims court's very inexpensive. It's under $100, I think, to file, or at least was last time I looked.
Still is, yeah.
Okay.
Yeah.
And there's no discovery. He mentioned that. There's no motion work, so there's no lawyers, nothing. And you're at trial within a couple months, and you're done. Over. Superior Court, yes, unless you're a corporation, we're talking about individuals today, you have the right to represent yourself. It is insane for you to do it. Our system isn't designed for lay people. There are thousands of statutes and rules, from the rules of civil procedure and the civil code and the evidence code, controlling all manner, and rules of court, all manner of how, the font, the spacing, everything is controlled.
Yeah.
You are not equipped to know that. A lay person is at such a big disadvantage to a party that has a lawyer that it is insane for a lay person to represent themselves. It's insane. So you might technically have a constitutional right to do it. And in my opinion, you're an idiot if you do. Okay? So you need a lawyer in the Superior Court. Superior Court, post-COVID, you're at least 2 years out from trial from the day you file. And there is discovery, there's motion work, there's rules of evidence, there's disputes, there's hearings, there's depositions, which is form of discovery, and there's all sorts of written discovery. It's complicated.
Yeah.
It's lengthy, and it is monumentally expensive. Okay. So small claims when it's simple or the money's little, under 12.5, everything else Superior Court. Easy peasy. Step 7. You mentioned this earlier. This is, you need to do, before you file, you need to do a fee shifting analysis.
Oh.
We did an episode last week. It just aired this week on fee shifting, and I have a fact sheet as well on this. Fee shifting means when I win, will I get my attorney's fees? Okay? That is a very important factor in determining whether you're going to file a lawsuit at all and how much you want to spend.
Yeah.
But that's not where the debate ends. The debate is a little more complicated than that because it's okay. If I win, I get my fees. Great. That's fee shifting. But it also takes into account what happens if I lose. Now, there are 3 kinds of fee shifting statutes. I named these. This was a personal name. Nobody else has done this, so you won't find this by Googling it. Or if you do, you might just end up back on my documents once Google crawls everything. I called it Category 1, Category 2, Category 3. Category 1 are cases where the fee shifting statute awards the prevailing party, the party that wins, their attorney's fees, whichever side it is. If homeowner wins, I'm the plaintiff here, I'm the homeowner, I sue, I win, I get my fees. If I sue and the HOA successfully defends and they win, they get their fees. That's Category 1, mutual. Category 2, there's only actually one statute in the Davis-Sterling Act that fits into this category, and that is called a one-way fee. And that is homeowner wins, homeowner gets fees. HOA wins, no fees, no matter what. That's Category 2. There's only one statute, and that deals with, do you remember?
EV chargers.
EV chargers. Great. We have multiple articles on that. Okay. And then Category 3 is homeowner wins, homeowner gets fees. HOA wins, HOA gets fees, but only if the court finds that the homeowner's lawsuit that they just lost was frivolous, unreasonable, or without foundation. And that is a high standard, and so HOAs almost never meet that. And so really, for all intents and purposes, it's a one-way statute, but it does allow for the possibility. Obviously, Category 1 is less desirable than Categories 2 or 3. Right?
Absolutely. 100%.
That's logical. We don't have to explain why. I think it's self-explanatory.
Heightened burden for the HOA. Yeah.
The importance of that analysis is which causes of action do we allege and which do we stand on versus dismiss or not even bring. For example, I think the good example we brought up, what was the example we brought up the other day? Now it's slipping my mind. You remember?
Well, the category 3 ones, the most common ones that come up are under 5145.
No, I know.
Okay.
I wasn't talking about that. I'm talking about the leverage in choosing your cause of action. Why? Like there are. Oh, I know what it was. One of the category 3s is that, or category 2 was that EV statute, right? Okay. If you violate that statute and you sue, if the HOA violates that statute by not letting you put a charger in your common area or exclusive use common area parking spot, let's say, and you sue under that statute and win, you get your fees. If you sue under that statute and somehow lose because you were wrong, they did let you, I don't know, the HOA doesn't get their fees. If you were to sue under breach of governing documents, let's say there was a governing document, let's say the governing document said that the HOA had to let you build the EV charger in the exclusive use common area.
You're in category 1.
And you're in category 1 on that. And if you lost, the HOA would get their fees. So if that was the scenario, you would sue under this and not use that fact to justify a breach of CC&R's claim.
Yeah.
Right? You might have breached CC&Rs for something else, but not that one. Because you'd be giving up a category 3 or 2, which is one way in favor of that. And if you were to somehow lose, you would have just awarded the HOA their fees, whereas if you would have stuck with the statute, category 2, no fees no matter what. That's what we mean by taking that into consideration, deciding how to proceed. So it's very important to think about fee shifting statutes and which ones apply to which causes of action so that you can take the best course of action.
And that same determination applies to category 1 versus category 3s, which is the more common set of statutes, right? The Open Meeting Act, or let's say the conversion from, let's say, standard common area to exclusive use common area.
Under 4600.
Under 4605. Or the other one that's common under the election challenges under 5145.
Those are all 3s versus your run-of-the-mill enforcement of governing documents fits under 5975, which is category 1. Now, don't get me wrong. The default position in the law in California and throughout the United States is something called the American rule, which is nobody gets attorney's fees when they win unless there's a contract or a statute that awards them. Fortunately, the Davis-Sterling Act has multiple statutes that award them, including the ones we were just talking about. So even if you're in category 1, that is absolutely a win. Assuming you win, okay? It's a win because you'll get your fees back. If you are in a lawsuit that has no attorney's fees clause, you're not getting your fees even if you win. I'll give you an example. Let's say your CC&Rs are one of the few that do not have a nuisance provision, and you have to sue for a nuisance. So you sue under the statute or in the civil code for nuisance. It doesn't have an attorney's fees clause, and there's no contract that awards it because your CC&Rs are silent. No fees for the winner. So fee shifting statutes are important not only to determine whether or not you get your fees if you win, but also whether or not you're going to have to pay somebody else's fees if you lose.
That's right.
And that helps you determine. Step 8, understand your available remedies. We have clients come into our office every single day and throughout the pendency of cases demanding the world and the kitchen sink on top of it. I want this, I want that, I want this, I want that. We were just talking, we just ended a case, we terminated our representation of a client who insisted that he was entitled to X, Y, and Z when we showed him on numerous occasions why he wasn't entitled to X, Y, and Z, and that wasn't something that the law could give. If we could get it, we would. But the law won't give it to you, and he would not take that as an answer. And you can't represent somebody like that because they're not seeing reason, right? That's what we're talking about here. How frequently are you running into this? These people, these clients, and we understand why. They are, here's how I've been hurt, and I want compensation.
Well, to answer your question is all the time, routinely, daily, to most of our clients' credit and the homeowners we do consultations with, once you explain it to them, they get it.
Most of the time, yeah.
Most of the time, yeah.
Right. But what I mean is we have people asking for what we're talking about is they're saying at the end of this, for example, I want that director off the board forever. I need the court to order him to stay off the board. And we would explain we can't get you that. It's not going to happen unless he's not a member. We can't get you that. We think it's deserved. That's the way it should be. But we cannot ultimately have the court put into our judgment that this person can never be on the board again and must step down.
I really need to say these two.
Yeah.
These two are the ones that just kind of,
tell me, that's what I'm looking for.
Where I have this red flag moment and have to have a major conversation with folks.
Go for it.
I want the association dissolved over routine disputes.
Right.
Well, or I want a court-appointed receiver appointed and involved.
But we can sue for receivership. There is a cause of action for that.
But I get these under more routine disputes.
Oh, right. Okay.
That
Fair
are
enough.
Okay.
Let me give you
being resolved.
That's good. Let me give you the two most common ones that are available in certain kinds of cases, but not in all. And then we're going to move on because we're longer time than I intended to be. Punitive damages. Punitive damages are only available in some kinds of cases. They're available in some of the more egregious intentional tort type cases, breach of fiduciary duty, if you can prove what's necessary under the statute to prove to be entitled to it. But you're not getting punitive damages, for example, in a breach of contract or breach of CC&Rs case, because it's not a remedy available in breach of contract or breach of CC&Rs. Emotional distress damages. I'm doing an article today on that. I will be publishing it today. They aren't available in negligence cases, just mere negligence. You might have actually been emotionally distressed as you would describe it. I have had stress and fear, and I've woken up in sweats and all this. But under the law, that cause of action that we're alleging, negligence or nuisance, isn't going to be enough to justify emotional distress damages. It's not going to be available. Mm-hmm. The remedies you're seeking have to be remedies that are available for that cause of action. Yeah. That's part of what we as lawyers do, is we tell you what remedies are available. Last step, step 10, step 9, is prepare, file, and serve the complaint. And I'm going to handle this very briefly. It's very simple. When you've done all the other steps, you've taken every step up to this point, you're now ready to write the lawsuit. A complaint is just that lawsuit. It's the thing that you file with the court that says, here's all the things that we're alleging against you that they look at and they've been served. You've been served, like in the movies. It's that complaint. That's the lawsuit, okay? So once you file the lawsuit, you have to serve it. There's a special way to serve it. It has to be done a certain way. And then the other side, the HOA in this case, is going to respond. And they might respond with a demur. We won't talk about what a demur is. Or they'll respond with an answer, which is basically, okay, here's my answer to your allegations. I deny your allegations. And here's some of my affirmative defenses. Let's rock and roll. Once the case is at issue, which means once an answer has been filed, you've gotten over demurs. Once an answer has been filed, the case starts. And that's when you get into all that written discovery, you get into depositions, you get into different kinds of motions, and eventually if there might be a mediation or a mandatory settlement conference order by the court. But eventually, if the case doesn't resolve itself, eventually you're going to have a trial date. You're going to end up going to trial, and you're going to put on your case. They're going to put on their case. A jury or a judge, depending, will make the decision, and then you have a verdict and you're done. So that's step 9. Mm-hmm. That's preparing, filing, and serving the lawsuit. Mm-hmm. Folks, suing your HOA is appropriate in lots of circumstances, but it has to be done systematically. And I think today we did a good job covering the 9 steps that involve properly suing your HOA. If you do all these 9 steps and you do them well, then you're set up for a very good lawsuit, and you're set up maximally as possible for victory. Okay? If you skip these steps or any of these steps, you can find yourself in a world of hurt, especially if there's a fee-shifting statute that does award the HOA their fees. Or if you ignore some of these steps and you end up alleging a very frivolous lawsuit or one without factual foundation, because that was one of our steps, you could find yourself being on the hook for attorney's fees. If you like this episode, please hit the like button. And if you haven't already done so, please subscribe to our channel, HOA Hell. If you want to leave a comment, as always, we love to read those. Until next time, have a wonderful day.